but he said it to the court twice. He said, everyone told Judge Kishner that this was going to be a 2-month trial. That is a falsehood, Your Honor. This is a direct quote from our attorney to Judge Kishner.
All right, we're going to move on to the contested matters. Next up, page 10, Orion Gallagher versus AffinityLifestyles.com, Inc.
Good morning, Your Honor. Will Kemp for Kemp Jones with Eric Pepperman, representing 6 to 7 plaintiffs. Good morning, Your Honor.
Morning.
Good morning, Your Honor. Theodore Parker on behalf of Chief Haley. Your Honor, I just associated in last night with my first appearance in this case.
All right, good morning, sir.
Good morning, Your Honor. Joel Odou on behalf of the real water entities.
Good morning, sir.
Good morning, Your Honor. Jim Neale on behalf of United Natural Foods West, Inc.
And good morning.
Thank you.
Good morning, Your Honor. David Spurlock on behalf of United Natural Foods West.
And good morning, sir.
Good morning, Your Honor.
All right, and I think that covers all appearances. Is that correct, ma'am?
Good morning, Your Honor.
Oh, I'm sorry. I don't want to overlook.
Representing Hanna Instruments.
Okay, go ahead and get that appearance again, sir. I just want to make sure I don't overlook you.
Yeah, good morning, Your Honor. Attorney Daniel Klett on behalf of defendant Hanna Instruments.
All right, good morning, sir.
And good morning, Your Honor. It's Rob Robbins, 6109, on behalf of Milwaukee Instruments.
All right, sir. Good morning. Does that cover all appearances? All right. Okay. And I guess for the record, it's my understanding we have a motion for the preferential trial setting pursuant to NRS 16.025.
Yes, Your Honor.
All right.
Your Honor, I'd like to start with the big picture. After these cases started being filed, there's currently 11 cases filed by our firm, and we filed them in groups of 6 or 7. And the reason is, to make them more able to be tried in one grouping. But in any event, the Gallagher case is one of the first cases filed. Orion Gallagher is an infant who ingested real water and suffered liver damage. And this also includes the Ryerson case, Kathy Ryerson, who actually died from ingesting real water. And there's 5 other plaintiffs in the case. And the typical pattern here is they ingested real water, they had severe liver failure, they went to the hospital 4 to 8 days in intensive care. That's the typical pattern in these cases. In addition to our cases, there are 2 other cases, one filed by the Eglin firm for Lisa King and one filed by Colby Williams for another infant. So we estimate that at present there's 60 to 65 victims that have filed suit. We intend to file another case in the immediate future, but we think we're getting pretty close to the universe of cases, just because the statute's arguably going to expire early next year. So, with regards to the 11 cases that have been filed, Judge Kishner has already set 4 trials starting in January 2024. And as you may know, she's involved in the opioid case next year, so she intends to try that. But then she's dedicated all of 2024 to real water trials. We think it's a pretty simple case. Real Water had a manufacturing plant first it was in Desert Inn, and then they moved it to Henderson. They made water. The water clearly was adulterated, and I'm not saying anything that the FDA is not saying. The FDA investigated this, tested the water. They filed a consent decree in front of Judge Dorsey in federal court, and the consent decree clearly says that the water was adulterated. The discovery status of the case is, from the plaintiff's side, I think we've been pretty diligent. We produced the medical, and I'm referring to the Gallagher case, the 7 Gallagher plaintiffs. We produced our medical records and the treating physicians in a 16-1 supplement in July of 2022. And then Special Master Hale, who was appointed by this court and all the other judges in all the other cases to be the special master, he and the defendants came up with groups of interrogatories, and then rather than each defendant sending separate sets, they have a master set, which is pretty commonly referred to as a fact sheet. In any event, we responded to the master set of interrogatories on September 23rd, 2022, and 7 weeks went by. There were no objections. When this motion was filed, we immediately got objections. They wanted supplements. We have actually supplemented I think most of their objections, as of present, we're going to supplement the rest of them because we didn't want any complaints that the plaintiffs were dragging their feet, and that's why the case couldn't be tried. With regards to the motion for expedited trial, there's no dispute that Mrs. Arnone, who's one of the 7 plaintiffs in the Gallagher case, is 75 years old. 16.0251 applies, preferential trial. One of the defendants makes a brief argument that, okay, you can't just be old, you also have to be infirm. That's not what the statute says. Old age in and of itself is a grounds. And like I've already said, she's 75. 70 is the mark. And then their second argument is that 16.025 is a meaningless statute that doesn't apply because the court has discretion. We quoted the legislative history. I think the legislative history makes it pretty clear that this was intended to be a serious statute so that people over 70 had access to the courts before they died. I don't know how much they want to argue that, but in this jurisdiction, as the court's aware, in the endoscopy cases, motions for preferential trial setting were filed in those cases, granted, and that's how those cases went to trial when they did. In the HMO cases, a spinoff from the endoscopy cases, you had the case of Helen Meyer. That was the big HMO case. And Ms. Meyer was over 70, and that you granted the motion for expedited trial date in that particular case. And I'd also point out that I had a case, Rogers versus Wynn, where you granted the motion for expedited trial for Mr. Rogers. And both the Meyer situation and the Rogers situation were because they were over 70 years old. And it's the general practice in this district to grant these motions. Now, the defendants argue, oh, gee, there's a lot to do. We can never get ready. It'll take 95 years to get this case ready for trial. I'm exaggerating slightly, but that's the standard defense position, Your Honor. In this particular case, we have the benefit of some pretty comprehensive governmental investigations. Both the CDC, the Southern Nevada Health District, and the FDA have investigated this matter. The CDC and the Southern Nevada Health District have issued a report with findings on 16 of the victims, including Mrs. Ryerson, and they did testing on the water. All the test results have been that we have got and the defendants have got have been produced and filed in the joint warehouse, so they have the benefit of that. And in the CDC and the Southern Nevada Health District report, they actually find that Mrs. Ryerson, the probable cause of her death was ingestion of real water. So I say that just because we're not starting with a blank slate here. I think there is a lot of discovery remains. We've been trying to get discovery going, Seems like every time we notice a deposition, there's an excuse as to why they can't be deposed. In the opposition, they say that the inventor, Mr. Marlowe, is a critical witness. They never tell you that we had his deposition set for tomorrow, December 1st, the day after this hearing. But they argue in the opposition, we can't try this case because we've got to do this deposition. So the very same day that they filed the opposition, I get a letter from them saying, we can't do Mr. Marlowe now because he's sick and old and blah, blah, blah. We have resolved that with them, and the Marlowe deposition is now scheduled, I think, for the 16th of December. But, remember, the plaintiffs have the burden of proof here, Your Honor. And I think I can get the case ready for trial. So from their point of view, what they really have to do is do some damages discovery on the plaintiffs, which I expect them to do, and there's plenty of time to do that, given there's only 7 plaintiffs. Now, how long do we think the trial will take? We've estimated 5 to 6 weeks. They come in and they make an argument, no, they told Judge Kishner it will take 6 months. That is just not true, Your Honor, and that's why I put the transcript in the reply, word for word, so you can see what was actually said to Judge Kishner. We said 5 to 6 weeks. Our belief is that, like the endoscopy cases, we're probably going to have to try at least 2 of these cases, maybe 3. And the reason for that is I think Real Water gets it, but I don't think the other defendants get it. And so I don't think there's any potential for a global settlement until we establish some parameters through some trials. And that's why we would like to get started and do a trial. Now, 120 days from now takes us to April. I don't know what the court's calendar is. I don't know what time you have available, if any, in April, May, June. But obviously we're flexible in that regards. So, Your Honor, for those reasons, we'd ask that you grant the motion for expedited trial. And with regards to deadlines for fact discovery, expert reports, the like, we're going to work with Special Master Hale on that. I'm not worried about that. I think if counsel can't agree to it, I think he'll impose deadlines that'll work out and allow us to try the case. But in any event, for that reason, we'd ask that you grant the motion and set this matter down for trial.
Okay, thank you, sir. We'll hear from the opposition.
Thank you, Your Honor. Joel Odou on behalf of the real water entities. Just a little bit of a recap. There are about 20 cases, we're approaching 20 cases that have been filed that eventually will be coordinated for discovery purposes. There are 78 plaintiffs as of today in those cases. As the court's well aware, the parties stipulated you have this matter designated as complex discovery with Floyd Hale. Mr. Hale has been coordinating all discovery in this case, and it doesn't make any sense now to throw the baby out with the bathwater and try to shoehorn this case into a trial date in 120 days when we have so many witnesses in this case. As we set forth in our papers, we have numerous parties that are going to be deposed. I think the thing that the plaintiffs left out was these depositions that they've said have been unilaterally set, at least as far as Mr. Marlowe goes, and he's represented by counsel. His counsel, and he contacted me and asked for a different date. We provided that date. His deposition is going to go forward on December 16th. So any argument that somehow the defendants are dragging their feet is just not accurate. In addition, the plaintiffs take issue with the fact that the fact sheets, the objection was made some period of time after they started coming in. Fact sheets were produced on a rolling basis. Finally, Your Honor, we would just note that the legislative history of the preferential trial statute doesn't conflict with the Code of Civil Procedure. This case was set with a special master to coordinate all discovery and come up with a schedule. We would argue that if the court's inclined to grant this motion, the court should have Mr. Hale get with the parties and come up with a schedule that works so that we're not in front of you on a motion to continue that's allowed by the statute if good cause is shown. We can see there's already good cause with the number of parties, the number of issues, complex case. This case should be set for trial in an orderly fashion rather than a stampede to trial as being suggested. So if the court is inclined to grant the motion, we would argue something in the time frame of August or September would make a lot more sense. And to order the parties we're going to see Mr. Hale this afternoon. We can certainly come up with a schedule. It's not going to be ideal if we're trying to cram it together, but that's just the way it is. These cases, in all cases, should be set for orderly discovery. The court has the authority to set its calendar in a manner that makes sense, and that's all we're asking for, Your Honor.
Thank you, sir.
Good morning, Your Honor. Jim Neale on behalf of United Natural Foods West. I'll be brief and try not to restate things that have been stated. I don't think it'll take 95 years to prepare the case for trial. I do think that Judge Kishner, with all the attorneys 5 weeks ago, came up with a very realistic schedule in which she allowed 13 months for discovery. The first trial was set of January 2024, and that first trial is set to go for 4 months based on what all the attorneys told her 5 weeks ago. I understand that plaintiffs may want to get to a verdict sooner than that, but the simple fact of the matter is that the case they brought forward doesn't allow it. 16.025, Your Honor, does give the court discretion, of course. It says may, not shall, and there are plenty of reasons the court should either deny this motion or grant it with a realistic discovery schedule, which is not 120 days. Contrary to what Mr. Kemp said, liability is not at all clear here. Even if there was adulterated water, I don't think the consent decree, Your Honor, is going to be admissible in this case. But even if there were adulterated water, there's still a question of causation. Mr. Kemp left out entirely the fact that retail and distributor defendants, like my client, UNFW, sold and distributed water from an entirely different facility than the one here in Las Vegas, an entirely different distribution channel. Only 2 of the plaintiffs in this case even have claims against UNFW. And the one on whose behalf this motion is filed is not one of those. There are 7 plaintiffs, 8 counts, 5 defendants, 2 cross claims, 1 third-party claim. It's simply, it is a complex matter. Your Honor, this was, Mr. Kemp said that the plaintiffs had been diligent. I agree that they have. We do have medical records. We do have a computation of damages. And we do have fact sheets. We got none of those on time, Your Honor. And I guess shame on us for not more quickly objecting. But the simple fact of the matter is we realize that there's a lot to do here. And we didn't run to the court or run to the special master when the plaintiffs missed a deadline on each and every one of those. Instead, we met and conferred. We picked up the telephone, we wrote letters, and we worked with Mr. Pepperman and Mr. Kemp in relatively short order. There are still issues that remain with that, but it's probably easier to say what hasn't been done in this case, Your Honor. There's been no written discovery answered at all. There was none served until after this motion was filed. There's been not a single deposition taken. There was none noticed until after this motion was filed. There's obviously been no IME, expert disclosure. There's been no samples taken from the Henderson, Nevada real water facility to analyze. And there's been no testing of any real water or any real water ingredient. What we do have, Your Honor, are 167 fact witnesses that plaintiffs disclosed. 75 that UNFW has disclosed. 78 that Real Water has disclosed. 16 that Milwaukee Instruments has disclosed. If my math is correct, that's 336 before we get any from Hanna Instruments and before we get any experts. If we were to do...
Now, explain to me why that's necessary. And the reason why I say that is this. I don't mind telling you this. This isn't my first rodeo as far as complex civil litigation. And this is a bodily injury case. It's a personal injury case. I understand medical causation. I understand Morris-Ocado, Hallmark, the Williams case, and so on. And my point is this. I would anticipate that there should be discovery as far as the product itself, right? Water. And I get that, but why do we need to take 333 depositions of individuals in this case?
I don't think
I would look at it, plaintiff might have 1, 2, or 3 experts, defense potentially the same thing. Testing can occur. I would anticipate from an evidentiary perspective, there's been preservation of evidence and the like. And so, and the way I'm looking at this, and correct me if I'm wrong, and trust me on this, and I will say this, there's no question there's discretion given to me pursuant to NRS 16.025. However, I do understand the thrust and the mandate from our legislature. And so what I try to do is this, and I can tell you this, I don't think I've ever denied a preferential trial setting motion in 17 years. But what I do is kind of like what Mr. Odou was suggesting. Look, Judge, if you do it in such a way where it's right? And that's kind of how I see it. But my point is this: I can't let it. I mean, I'm trying to figure out what all is necessary from a discovery perspective, right?
I understand, Your Honor, and I'm not asking the court to deny this for the first time ever. I agree with Mr. Odou that what you impose should be fair, and it should allow for the full discovery of the case. In particular, because...
But when we say full discovery of the case, I wouldn't think it would require the deposition of 333 individuals.
I'm not suggesting it does, Your Honor.
Right.
Even if we assume that a relatively small fraction of those people need to be deposed. Let's say, and there's certainly overlap among those designations, but if there's only 100 people that we want to talk to or depose, that's a person a day. Never mind IMEs, never mind motions practice, never mind anything else.
But how did that proportionality requirement as far as discovery is concerned? Because I'm kind of looking at it from this perspective. I mean, of course, you have to have liability experts, and how many liability experts would the defense have and the plaintiff have in this case? Just as important to, I understand medical causation might be an issue here. I don't know if there's going to be an epidemiology expert. I would anticipate. I mean, I don't know much about the case factually as far as the injuries are concerned. Maybe you might have an internist or some sort of medical specialist. And so on and so on, maybe a liver specialist. I mean, I don't know, but I'm looking at it from that perspective, from of course, determining whether or not there's some sort of defect in the product and or tainted water, and then what is the medical causation in this case, you know? And then at the end of the day, and because it's my understanding the request is being made for one plaintiff, is that correct?
No, it's for the 7, Your Honor.
7, okay.
And I think that illustrates the problem, Your Honor. Only the one plaintiff is eligible to make the request. That one plaintiff doesn't even have a cause of action against all the defendants. So UNFW, for example, is being dragged along with the others. I understand why we're here, and I'm not complaining about that. But the simple fact of the matter is that there are all of the experts you mentioned above, manufacturing experts from 2 different facilities, despite the months-long investigation by public health authorities, the Food and Drug Administration, the Centers for Disease Control, the Southern Nevada Health District, they haven't found a problem with the water, Your Honor. They've never found a causative agent. This remains a public health mystery, and this is not going to be an easy case to put on or an easy mystery to solve. It's going to take some time. It's going to take some experts. It's going to take some discovery, and if we try to cram this down into an unrealistic period of time, it's not only going to affect the discovery in this case, Your Honor, but because we may not get a second bite at the apple with a lot of these public health authorities or with the experts or with the non-party manufacturing employees, the former employees, it may affect all the other cases as well. And so I would ask the court to please consider the amount of work that needs to be done. When we were in front of Judge Kishner last month, everybody agreed that the shortest of these trials, the 4th one, would likely take 2 months. The first one, everybody agreed, would likely take 4 months. That involved fewer plaintiffs than this case.
And why would that be?
I think it's a function, Your Honor, of the number of plaintiffs, the number of providers for each plaintiff, the number of experts involved, and perhaps first and foremost, it's a function of the fact that nobody knows yet what happened here. Like years and years of investigation by the nation's leading public health experts, nobody can point to a problem and say, this did it. And so we've got a lot of people, a lot of smart people in a lot of places around the country scratching their head. But this is going to take some time.
So here's my question. In that regard, I would anticipate that the plaintiff has experts to opine as to what did it, right?
We don't have any idea whether that's the case or not.
Okay. I would think that would be their burden.
It absolutely is.
Right.
It absolutely is.
I would. If not.
And while it's not technically the defendant's burden, you understand, of course, that we'd rather come into court saying that we know that didn't do it. And so we are doing everything we can for a number of reasons to try to isolate the issue here and discover what really happened. That's going to take much longer than 120 days, Your Honor.
No, I understand that. That's why once again I commented on Mr. Odou's comments. And I mean, when I look at it from this perspective, I don't mind saying it. If you could probably go back and look at those cases where I granted a preferential trial setting, I'm quite sure I did it in such a way where, yes, I shortened. I gave a firm trial setting clearly within a shorter period of time that normally would occur, but nonetheless it was done in such a way where it was fair.
I understand that. I've made my point. There's a mountain of work to be done here. This trial, especially if it's the first one, will take, I think, much longer than Mr. Kemp's 6-week estimate. And I'd ask the court to more realistically set a discovery schedule that allows all the parties to fairly meet their respective burdens coming into court.
I understand.
Thank you, Your Honor.
Your Honor, this case is
I'm just looking for anyone else sir.
Nothing, Your Honor.
Okay, because I don't want to overlook anyone.
Appreciate it, Your Honor.
Yes.
Scott Rasmussen on behalf of Hanna Instruments. I'm sorry, I was over in Carolyn Ellsworth's, Judge Ellsworth's courtroom, and so I'm going to be on side. We would concur with what's been said as well and agree that we probably need to find something that's fair for everyone. We're just getting into this case, Your Honor, and have a lot of things to do. And ours is a different standard than what's going to be probably for the real water defendant. So there's 2 or 3 things going on here, and I think we're only on a couple of causes of action. So, and different parties. So we would just request that the fairness that we be shown to my client so that they're not prejudiced and having something that's ambushed on it. Thank you.
All right. Mr. Kemp, sir.
okay. Your Honor, first of all, Mr. O'Neill said that plaintiffs missed the fact sheet deadline. This case is 18 months old. Mr. O'Neill has not even filed his insurance policies, not even filed his 16-1 required insurance policies yet. That gives you an idea of what the defendants are really doing in this case. Now, Mr. O'Neill also says, and he said it twice, and I kind of let it go during my opening argument, but he said it to the court twice. He said, everyone told Judge Kishner that this was going to be a 2-month trial. That is a falsehood, Your Honor. This is a direct quote from our attorney to Judge Kishner. Quote, it's our position that trial would take no longer than 6 weeks, unquote. We didn't say 2 months. We didn't say 6 months like they said in their paper. We said the exact same thing we're saying now, 5 to 6 weeks. So basically, it's as I said.
I don't mind telling everybody this, whether it's 6 weeks or 2 months, it doesn't matter.
Yeah,
I mean, it
I don't
really
think
doesn't.
it really matters.
Once
Your
you
Honor,
start trials, they just have a life of their own. Lawyers historically are very optimistic, and we've had a lot of cases that are very complex go to trial in this department over the years. And I can say this, only about 5 to 10% meet the estimated time, right? So I'm not even worried about that. I will tell you this, this is my concern, and because I'll just say this, in 17 years, I've always, I know Mr. Kemp, you said, look, Judge, you did this before. There's no doubt I did, but I bet the way I did it, I did it in such a way where we didn't follow the strict 120-day mandate, right? We kind of worked it out, and I definitely gave the preferential trial setting. I don't mind saying it. I mean, once you get over 60, you understand why the 70's there, right?
and like I said,
right? You understand why that's there, right? And so you don't want. I mean, this from a public policy perspective. If someone's, in their, I won't even call it golden years, but they're later in life and they're mature. It's probably the best way to say it. You want to make sure that they have an opportunity to have their case heard. That's and that's really and truly what it's all about, right? And I get that, and and this is the public policy of our Nevada legislature. They give me discretion. I think the reason why they put the discretion in because our Nevada legislature had insight to know that maybe you can't shoehorn it in exactly, but Judge, this is what you should do.
Right.
And that's what I'm looking at.
And 120 days actually takes us to March 30th. I'm
Right.
not arguing for that, Your Honor. I'm saying give them another month or two of the discovery, set it down sometime in June. Their proposal.
So we're not that far off, at least with Mr. Odou discussed, right? What did you say, sir?
September, or I guess
Did
he
you
said
say
August,
August?
September.
August, September.
Yeah.
August,
Well, it's not
September.
that big of a deal.
Yeah, I just think June would be better because I've been down here in July. I'd rather be here in June. But in any event, Your Honor, turning to the real water points, they said the special master should be involved in setting the deadlines for things if we do an expedited trial. We agree, and on the agenda today, this is on the agenda with the special master.
I understand.
Already. And we brought this up at the last special master hearing that we intended to file a motion for expedited trial. So I fully expect Special Master Hale to be able to handle this matter. So for those reasons, Your Honor, we again would ask that it be set down, if not in May, at least in June, Your Honor, because like I've already said, there's a number of cases. We're going to be with Judge Kishner, and she didn't set the case down in 2024 because she thought the discovery period would run that far. She set the case down in 2024 because she had the opioid trial in 2023. That is the real reason she set the case down in 2024. So to suggest that she made some kind of balancing decision, looking at all the witnesses that need to be done, and came up with 2024, that's just not accurate, Your Honor. For these reasons, I don't know if Mr. Parker has anything to say, but for these reasons, we would ask that the court at least set it down in June if it doesn't give us May.
Your Honor, if I could, just briefly.
Yes.
So, Your Honor, like I said, this is my first day in the case, and I was actually happy to see Mr. Odou on this case because he and I have had the pleasure, now I see Scott Rasmussen here, we've had the pleasure of being before this court where you've been able to harmonize NRS 16.025 and NRCP 16F. You've done it in countless CD cases, Your Honor, when you were on the CD court. You've done it with Sun City cases, where the majority of those plaintiffs were over the age of 70. You found a way to do it for the likes of both the plaintiff and the defense bar. So I don't believe that the request is out of hand. I think it's in keeping with what the statute provides. And I think Mr. O'Neill would have this court turn the process on its head. Typically, the court decides the trial date, and then the special master works within that trial schedule. And so I believe you'll be able to come up with a date and a time that's fair and allows for the discovery to be done on both sides of the V, Your Honor. The other point I wanted to make in looking at the opposition tries to suggest that there was some improper joinder, and I don't think anyone discussed it orally today, but that motion, if there was an improper joinder, that should have been brought up months ago. This is not the time for it, and it's not proper procedurally to bring it up in opposition to a motion for preferential trial setting. The other point, and I think Mr. O'Neill may have mentioned this, there's considerable overlap in the designation of witnesses, and you've seen it countless times in 16.1 disclosures. That's what we have here. Each of the parties have named similar witnesses, similar 30B6 witnesses, and so there's not 333 different witnesses that have been identified, Your Honor. This request, I believe, is in keeping with the statute, Your Honor. It does say may as opposed to shall, but it also has been encouraged by our legislature for those over 60 to get their day in court and perhaps even enjoy the benefits of a verdict. The only other point I would mention or make, Your Honor, is that when I look at the opposition file, it mentions and it tries to persuade the court through California citations. Not a single Nevada citation have I seen where it disputes the right of the court to do what's being asked by the plaintiff, Your Honor. So for those reasons, Your Honor, I certainly ask that the court give us a time closer to sometime between May and June. And I think that the special master, Hale, will be able to work within the confines of that schedule to get the discovery done. Thank you, Congressman.
Okay, anything else? All right.
Nothing further.
Okay, what I'm going to do is this. As far as the motion is concerned, I'm going to grant it. One thing I don't know is, I haven't looked at the discovery schedule in this case. And when are you meeting with Mr. Hale? Is that today?
Today at 4 o'clock.
Today at 4 o'clock. Okay. Okay, this is what I'm going to do, and understand this. We're I don't mind saying it, we're pretty jammed up in this department too, as far as business court matters are concerned. I'm going to grant the motion, and you can give these dates to Mr. Hale, and hopefully he can deal with it. The calendar call is going to be July 20th, 2023. At what time is that, ma'am?
It's at 10:30.
10:30, and this is going to be given preferential to be number one on the July 31st, 2023 trial stack. And probably you'll need that time anyway. That's what I
Repeat that one more time. July what?
July 20th for the calendar call,
Yes.
and the trial stack will be July 31st, 2023, 9 o'clock a.m. You'll be number one on the stack. Mr. Kemp, can you prepare the order, sir?
Thank you, Your Honor.
Thank you, Your Honor.
Yep, and I think that'll give you more time because you need it.
Appreciate it. Thank you.
Everyone enjoy your day.
You too, Your Honor. Thank you so much.
All right. Okay, we're going to move on.